Good evening. My name is Erin Choquette. I'm the General Counsel for the Connecticut Paid Leave Authority, and this is a information session on for manufacturers about the Connecticut Paid Leave Act. With me tonight is our CEO, Andrea Barton-Reeves, as well as our Executive Assistant Extraordinaire, Amber Forrest. We are going to record this webinar, so it'll be available to you to review and to share. In the future, we will also make the slide deck available to you. As I go through the slide deck, which will take approximately 30 minutes, if you have any questions, please use the Q&A feature in Zoom so that we can keep track of your questions and make sure that we answer them. We should have plenty of time after the end of the slide deck to address your questions as well. All right, I'm going to go ahead and share my screen so we can get started. Right, as I said, my name is Erin Choquette, and I am the General Counsel for the Connecticut Paid Leave Authority. Prior to joining the authority, I worked for over 14 years at the Connecticut Department of Administrative Services, which is the agency that handles all of the back office functions for other state agencies. All told, I have over 20 years experience as an attorney, primarily on employer side, dealing with all matters relating to employment, administrative law, legislative issues, with a significant focus on FMLA throughout my career. Tonight, we're going to talk a little bit about the Connecticut Paid Leave Program, and then we'll pivot to review where the Connecticut Paid Leave Act fits into the constellation of existing leave laws, looking at the role of the employer, how employees will apply for paid leave benefits. We'll talk a little bit about the private plan option, which is an alternative to participating in the Connecticut Paid Leave Trust Fund, as well as some information about how to register your business if you have not done so already. And as I said, we should have plenty of time for questions and answers at the end, but please feel free to put them in the Q&A function if you want to make sure you don't forget them. So the Connecticut Paid Leave Authority is a quasi-public agency. We were created by Public Act 19-25, which was the Public Act, which also established the Connecticut Paid Leave Law and created changes to the Connecticut Family and Medical Leave Act. The purpose behind the Connecticut Paid Leave Law is to provide individuals who need to take time away from work due to their own serious health condition or to care for a family member to be able to do so without suffering or worrying about the lost income associated with taking unpaid leave. So the mission of the Connecticut Paid Leave Authority is to provide employees with access to paid family and medical leave benefits and to empower employers and administrators and healthcare providers to help them understand their job in their roles in connection with leave administration and to provide them with the information and tools they need. At the authority, we have 5 statutory responsibilities. One is to engage in outreach and engagement. So we appreciate opportunities like tonight to provide webinars and to hear the questions that people are asking. We also have to stand up the quasi-public agency. It's a brand new agency, so we've been working to stand that up and developing the policies and procedures necessary to run the program. Under the statute, the Connecticut Paid Leave Program is entirely employee funded, and it's funded through contributions from employees' paychecks. The statute says that the contribution can be no more than 0.5%. But if in the future the trust fund reserves are solvent and are steady, we have the authority to reduce the contribution rate. So that's something that it's one of our jobs. We also have to receive the contributions that employers are now deducting from their employees. Employers will be remitting those to us on a quarterly basis. As I said, we'll talk about private plans, but for now, I'll just point out that we both review the applications for private plans and will audit those approved plans. And starting in January of 2022, employees can come to the Paid Leave Authority and apply to us for income replacement benefits if they're out of work. And so that will start next year. A few key dates to pay attention to. We created the Connecticut Paid Leave website, ctpaidleave.org. It went live in early September, and the registration function went live in November. All employers need to register with ctpaidleave.org and create an account. This is where you will remit your contributions. This is how you apply for a private plan. This is how you receive information about the program. If you have not done so already, please go to ctpaidleave.org and register. We can provide more information about that toward the second half of this webinar. Starting on January 1st of 2021, employers were required to begin deducting contributions from their employees' wages at 0.5%. Also, we've been working on those private plans. We've been receiving applications from employers that want to offer a private plan, and will continue to do so. Those contributions that you've been deducting from your employees' wages need to be remitted to the authority on a quarterly basis. Just as you remit your unemployment insurance and payroll taxes, you remit those on a quarterly basis. We have also established a grace period of 1 month after the end of each quarter. So as long as you get your contributions into us by April 30th, for example, you will be on time for quarter one. As I mentioned, starting in January of 2022, we can start making payments for paid leave benefits. Our goal is to open the application process in December so that people who know that they will be out on leave starting in January can apply to us in advance so that they have no disruption to their income. So that's what we're doing this year. Not a lot, just standing up an agency in a pandemic and trying to get everything going. The very first question we always get asked is, who is covered by this program? Who has to participate? And the legislation was deliberately very broad because the legislators wanted to make sure that a large population of employees had access to this benefit. So who is covered? Almost everybody. Employers who have one or more employees working in Connecticut are covered. This includes nonprofits. This includes private sector employers with unions. It includes employers who don't have to pay unemployment. They still have to participate in the Connecticut Paid Leave Program. The statute also allows sole proprietors and self-employed individuals to participate for themselves. Just like there's an opt-in for workers' comp for sole proprietors, there's an opt-in for those individuals who own their own business or are self-employed and want to opt in. There are a few classes of entities that are not covered under the program, and these are the same classes of employers who have never been covered under the Connecticut FMLA. And that includes the federal government. It includes the state of Connecticut, except as to covered public employees. Municipalities and local or regional boards of education are also not covered by the program unless they have covered public employees. Finally, non-public elementary or secondary schools are not covered. If you're not covered, it means your employees don't make contributions and won't be able to apply to us for benefits. Now, as you've noted, I've put covered public employees in quotation marks. That's because it's a term of art. It's defined in the statute to include these four groups of employees. Non-unionized employees of the state of Connecticut do participate in the program. We are remitting contributions and will be able to apply for benefits. Unionized employees of the state can collectively bargain to be included, and if they do so, they will become covered public employees. Employees of municipalities and of boards of education will only be covered if their unionized counterparts, so the unionized employees in that town or in that board, collectively bargain to be included. If they do so, then everybody, union and non-union, will become a covered public employee. There is no opportunity for private schools to opt in, and there is no opportunity for private sector employers to opt out of the Connecticut Paid Leave Program. As I mentioned, the contributions are entirely funded by the employees. So the employee is responsible for contributing up to 0.5%. Right now it is the 0.5%. And that is capped at the Social Security contribution limit. The employer, who handles the payroll, is responsible for remitting the contributions. So you need to look at your payroll calculate your employees' wages the same way you're already doing it for purposes of FICA. You take that FICA number and you take the 1/2 of 1% and you put that into their paid leave. You put that into the paid leave trust fund by remitting it to the Connecticut Paid Leave Authority. We will receive those contributions. We ask for very minimal information, basically the total number of employees in your payroll, and we validate that information, and we immediately deposit the funds into the Paid Leave Trust, which pays the benefits and the cost of the Paid Leave Authority. The Paid Leave Trust is administered by the state treasurer, but it is not a state fund. It cannot be swept or used for any purposes other than to administer the Connecticut Paid Leave Program. As said, the Connecticut Paid Leave Act is a brand new law that was enacted in 2019, but it fits into this constellation of other existing laws. There already are several laws in the books which provide for job-protected leave. If you're an employer with 50 or more employees, you're probably already familiar with the federal FMLA. And if you have 75 or more employees, you're familiar with the Connecticut FMLA. If you have fewer employees, you need to know that in January of 2022, the Connecticut FMLA will apply to employers with 1 or more employees. So this is something you need to learn about. In addition to the 2 FMLAs, workers' compensation does provide for a certain amount of job-protected leave. And the Americans with Disabilities Act, the Pregnancy Disability Act, and the Connecticut Fair Employment Practices Act have long held that an employee who has a disability may request leave from work as a reasonable accommodation. It's not an automatic entitlement, but it's something that must be considered. Up until the Connecticut Paid Leave Act was enacted, we really didn't have many sources of income replacement during leave. Obviously, there's workers' comp benefits for covered on the job injuries, but other than that, allowing an employee to receive income while they're out of work has really been up to the employers. And there are a lot of employees who have been left out of that kind of informal process. And so they passed the Connecticut Paid Leave Act, which, as I said, applies to most employers with 1 or more employees. And the income replacement benefits will start next January. It's important for employers to pay attention to the changes to the Connecticut FMLA because the FMLA is really what employers deal with. This is what employees will cite when they ask to have job-protected leave. Right now, and until January 1st of 2022, Connecticut FMLA applies only if you have 75 or more employees. And to be eligible for job-protected leave, you must work for the employer for at least 12 months, and you must have worked for at least 1,000 hours in the 12 months immediately preceding the date of leave. Starting in January of 2022, however, the eligibility will be available, leave will be available to employees who work for employers with 1 or more employees, and they'll be eligible for job-protected leave once they've been with that employer for at least 3 months. There will no longer be an hours worked requirement. The amount of leave will change too. Right now, it's 16 weeks in a 24-month period, although there's something called military caregiver leave, which is a one-time leave of absence of up to 26 weeks to care for an injured family member who's been injured on active duty. Starting next year, it will switch to 12 weeks in a 12-month period. You'll still have that one-time 26 weeks of leave for military caregiver, but there is an additional 2 weeks of leave that may be available if an individual is incapacitated during pregnancy, as demonstrated by their medical certification. The other big change to Connecticut FMLA is in connection with employers' policies regarding the use of accrued time. Right now, an employer can permit or require their employees to use any or all of their accrued time while they're out on FMLA. Starting in January, the law says an employer may permit or can require an employee to use their accrued time while out on FMLA. However, the employee must be permitted to keep up to 2 weeks of accrued PTO. Hold that in reserve and not be required to exhaust it while they're out on leave. So When can an employee take FMLA leave, and what are the reasons that they could receive income replacement benefits? Now, these are the same, the leave and the income replacement benefits, and this is the law as it will take effect in January. You can take leave to create or expand your family through the birth of a child or placement with foster care or adoption, which is usually called bonding leave. You can also take leave to care for a family member who has a serious health condition, which is called caregiver leave. Of course, you can take leave for your own serious health condition, and that definition includes not just injuries or illnesses, but also serving as an organ or bone marrow donor, as well as pregnancy. As I mentioned, there is a special leave to care for a family member who's injured on active duty in the military, which is called military caregiver leave. There is another type of military FMLA called qualifying exigency leave, and that allows an employee to take time away from work to deal with um, exigent circumstances, things that need to be dealt with because the family member, a parent, spouse, or child, has been called to overseas active duty, such as attending their sending off ceremony or having to make appointments with the bank and the lawyer to update your financial and legal arrangements. Connecticut has had something called family violence leave as an entitlement for over 10 years, or approximately 10 years. Um, this is leave that an employee may take if they're experiencing family violence, and they can take time away from work to relocate or go to court or to seek counseling or treatment. The Family Violence Leave Act says that an employee can take up to 12 unpaid days for these reasons. And under the Connecticut Paid Leave Act, an employee could come to the authority for income replacement for those reasons as well. The reasons that I just listed are very similar to the reasons that an employee could take federal FMLA. So you should be familiar with them if you've been dealing with the federal FMLA. However, there is a major difference, and that is how the Connecticut laws define family member. Under the federal FMLA, you can take caregiver leave only for a parent or a spouse or a child who is under 18 or is 18 and over and has a disability which prevents them from engaging in 3 or more activities of daily living. Under the Connecticut FMLA as amended in January and under the Connecticut Paid Leave Act, an employee can take caregiver leave and receive benefits, not just for their parent or spouse or young child, but also for a son or daughter of any age, without regard to disability status, or for their sibling, grandparent, grandchild, or an individual related to the employee by blood or affinity whose close association is the equivalent of one of those family relationships. So what does that really mean? Well, we're really talking about the chosen family. It's someone with whom your employee has a significant personal bond that is like a parent, spouse, sibling, grandparent, child, even though there's not a biological or legal relationship. This is going to be a fact-specific inquiry. Uh, and so your employee may come to you and say, my great aunt, who I've lived down the street from my entire life and for whom I do the grocery shopping and the laundry and who has been at every single event in my life from first tooth to prom pictures, is sick, right? And that person really took the place of my grandmother, that it would be an affinity relationship. Connecticut does not recognize common law marriage, but under Connecticut FMLA and Connecticut Paid Leave Act, you could have a situation where an employee says, my significant other, the person with whom I live, even though we're not married, is going in for surgery and I need time away to care for him or her. And that would be covered too. Okay. We get a lot of questions, and I know your employees will ask you a lot of questions about what exactly does FMLA consist of? And so that's what the next 2 slides really are intended to encapsulate. Under federal FMLA, you get 12 weeks in a 12-month period, except for that 26 weeks for military caregiver. As I mentioned, under Connecticut FMLA, starting in January, it will be 12 weeks in a 12-month period, with that 26 weeks for military caregiver, 12 days for family violence leave, and a person who's incapacitated due to pregnancy could qualify for an extra 2 weeks, so up to 14 weeks total. A person who is, and I just want to make a point here, if you have a person who breaks their leg in January, for example, and is out for 3 weeks, and then has a baby in December, in September, for example, they don't get a brand new 14 weeks. They get the 14 weeks minus the 3 weeks they've already taken. For Connecticut paid leave benefits, you can receive income replacement benefits for up to 12 weeks for all reasons, including military caregiver. We do allow for the 12 days of income replacement during family violence leave, as well as the 2 additional weeks of income replacement for leave associated with incapacity due to pregnancy. Just a quick reminder on eligibility requirements. Federal FMLA, it's 12 months, and you have to work 1,250 hours in the 12 months immediately preceding leave. As I mentioned, under Connecticut FMLA, starting next year, it will just be a 3-month test. Once your employees worked for you for 3 months, they're eligible for job protection. For the paid leave benefits, we don't actually look at how long an employee has been employed. We look at how much they're earning. You have to earn at least $2,325 in their highest earning quarter when we look at the first 4 of the 5 quarters immediately preceding the request for benefits. And those earnings could be from multiple employers. They could have multiple part-time jobs, or they could have recently switched jobs. So you could be eligible for income replacement benefits from the authority, even if you have no right to job protection. You do have to show, however, that you're either currently employed and working in Connecticut, or you were employed and working in Connecticut during the 12 weeks immediately preceding the request for leave. As I mentioned earlier, a sole proprietor or self-employed individual who's opted to participate in the program and has been contributing can receive benefits, assuming they make the 2325. All right. So that's a lot of information just on the overview of kind of what the laws are and how they fit. But let's talk about what happens in the workplace. What happens with you as the employer? This decision matrix is actually nothing new. This is something that you're probably already doing, even if you haven't really quantified it in this way. But basically, anytime an employee comes to you and asks for time away from work for a potentially qualifying reason, one of the reasons I've already listed, as the employer, you must assess, is this employee eligible for job protected leave under one or more statutes? And is the employee eligible for any income replacement? You need to look at both questions every time because the answers may be different every time. An employee could be eligible just for federal FMLA. They might be eligible only for state FMLA. They could be eligible for federal and state FMLA, in which case the leave will run concurrently, meaning that you're going to draw down on both leave entitlements at the same time. Some employees won't be eligible for either federal or state FMLA, but job protected leave might be a reasonable accommodation under the ADA or Pregnancy Disability Act or Connecticut Fair Practices Act, and you need to consider that. And some employees won't be eligible for any job protected leave at all. They may not be able to work, but they have no entitlement to have a leave or to have their job held for them. So the other question you have to think about is, what's going on with income replacement? Is this employee eligible for any sort of income replacement? And that's partly a question for you to answer and partly a question for the authority to answer. The paid leave authority will determine if an employee is eligible for benefits from the paid leave trust. But you have to decide based on your own policies, is the employee eligible to receive income based on their earned accruals or from your short-term or long-term disability policies? Under the statute, an employee can receive benefits from both the leave authority and the employer at the same time, provided that the combination does not exceed 100% of the employee's regular wages. When you have a short-term or long-term disability policy, you really need to look at the terms of that policy to see whether they use the policy benefits or they come to the authority. Most policies do tell employees that they have to go to a state-provided or employer-provided benefit first. It's worth pointing out that an employee who's receiving workers' compensation benefits cannot receive any paid leave benefits. It's just a flat prohibition. As we'll discuss in a few minutes, there is an opportunity for an employer to fulfill their obligations under the Paid Leave Act by offering a private plan. If you do so, you're standing in the place of the Paid Leave Authority, and you're offering a plan that will provide your employees with benefits that the authority would otherwise provide. If you have an approved plan, then you will be making the decision about eligibility for benefits. As I've already mentioned, you can require your employee to use accruals, but as of 2022, you can't say they have to exhaust all their accruals. You have to let them hold on to at least 2 weeks. So an employee will come to you as the employer to request time away from work. The employee will come to the authority to request paid leave benefits. When they do so, we will validate that the employee is eligible based on their earnings and that the reason for leave qualifies. We're responsible for calculating the benefit amount, but we will need to communicate with both you and the employee to validate when the employee is actually out and to calculate any offsets based on any employer-provided time off. And then we issue the benefit payments directly to the employee. The benefit payments depend on how much the employee earns. If the employee's base weekly earnings are less than or equal to the minimum wage multiplied by 40, they will receive 95% of their base weekly earnings. If they earn more than the Connecticut minimum wage times 40, their benefit rate will be a two-part. They'll get that minimum wage times 40 plus 60% of the difference between their weekly earnings and the Connecticut minimum wage times 40. However, in all circumstances, the total benefit is capped at 60 times the Connecticut minimum wage. Right now, the Connecticut minimum wage is $12 an hour, so minimum wage times 40 is $4.80, and 60 times the minimum wage is $7.20. So there will never be a circumstance under this calculation where an employee would receive more than 60 times the minimum wage. We have a couple of examples here just to show how this works in actual math. I'm going to skip through them just to get to some information about what happens when you have two employees who work for you. Federal FMLA says that they each get 12 weeks of job protected leave for their own serious health condition and for most leave reasons, except if they want to bond or care for their parent who has a serious health condition, in which case, if one spouse uses 10 weeks, the other spouse only gets 2 weeks left. They have to share that 12 weeks for those two situations. Under Connecticut FMLA, they actually have to share not just for bonding, but to care for any family member with a serious health condition. Under the Connecticut paid leave law, the entitlement to income replacement benefits is not shared. So even if you have two spouses who work for you and need to be out, each will be eligible to receive income replacement benefits, regardless of how much the other spouse receives. Okay, let's just talk briefly about those private plans. They're enabled under Section 3149.0 of the Connecticut General Statutes. This is not an opt-out as much as it is an alternative. You have to provide your employees with the same benefits that the Connecticut Paid Leave Authority would provide. Under the statute, if you're approved to offer a private plan, you do not have to remit any contributions to the Paid Leave Authority, and you as an employer are allowed to take up to that same contribution amount from your employees' wages to administer your own private plan. However, you cannot take more than the contribution amount, and you cannot use that money for any purpose other than administering your private plan. It cannot be blended with your other benefits. If you're interested in the private plan option, go to ctpaidleave.org and look at the I want to apply for a private plan page. On that page, there's a great deal of information, including a very detailed policy document, which includes some templates that you might be interested in, as well as the step-by-step process to apply. Because the plan must offer the same or better benefits as the paid leave program, you're not going to be able to just get approval by showing us that you have a short-term or long-term disability policy, because those policies don't cover all the same reasons. As I said, it cannot cost the employees more than the public plan, and it must cover all of your employees. If you're a multi-state or multinational, it has to cover your employees working in Connecticut. But the point is, you can't have a plan that covers the C-suite but tells the manufacturing floor that they have to participate in the public program. If you want a private plan, you have to cover everybody. Additionally, because the legislature made the Connecticut paid leave program entirely employee funded, they put into statute that the employees have to agree that they are willing to have the employer offer the private plan. So before you can apply to us with your private plan, you have to provide your proposed plan to your employees and let them vote. And a majority of all of your employees working in Connecticut have to approve the plan in order for you to submit an application. A number of insurance companies have developed private plan options. These are, as of today, this is the list of insurance companies that have been approved by the Connecticut Insurance Department to offer paid leave program, paid leave plans. You can also create a self-insured plan if you choose to. And we have template documents on our website. I'll note that if you choose the self-insured option, you are required to obtain a surety bond in the amount of your estimated contributions for the year. And that runs to the authority, and that's to protect the authority and the employees in the event that your plan does not have the funding. Okay, before we go to the questions, let me just talk a little bit about registration. We need you to register. You need to register now so that you can create your account so that you're able to remit your contributions when they're owed. It also helps us know that you have been required to remit or withhold that 1/2 of 1%. If you have not yet started withholding that 1/2 of 1%, we do have a slight grace period where you can make some catch-up. You can do some catch-up withholdings, but you can never ask your employee to provide more than 1%. And you have to complete your catch-ups by the end of the second quarter. So you really don't have a lot of time here. You really need to get those contributions withheld, and you need to be prepared to remit your contributions. If you fail to do so, you could find yourself in the situation of having to make your employees payments on their behalf, which is not something that I'm sure anyone has budgeted to do. Employers who fail to or refuse to withhold or remit contributions could also face additional monetary penalties. So get registered. It's very easy. It's a two-step process. Step one is to create an account with ct.gov. That is it's something you might have heard of as the Business One Stop or the portal. That is a state of Connecticut-wide initiative to create basically a single door through which employers can access the state for any reason. The Connecticut Paid Leave Program is one of the first agencies that is using the portal, but eventually all agencies will have you go through business.ct.gov first to create your credentials, and then you'll use those credentials for all agencies. So if you haven't done so yet, you'll do that now. So you go into business.ct.gov, create your account, and get your credentials. Once you have those credentials, you come back to ctpaidleave.org and you register your business. And it's just relatively straightforward. It's a couple of information about your business, your contact information, the size of your business, and then you'll be good to go. Once you're registered, you'll be able to remit your contributions at the end of the quarter. You'll be able to submit an application for your private plan if you choose to. Now, we want to make this process as painless as possible. We know that employers have a lot on their plates, and you have a lot of employees who want to know what's going on with these deductions. So we've created a lot of materials for employers to share with their employees. You can find all of this information at ctpaidleave.org. It's available, it's downloadable, it's all available in English and in Spanish, in color and in black and white. You can send it, print it, email it, whatever you need to do. But we have a poster, we have rec cards, we have mailers, we have fact sheets. There are also videos that you can use or link to your employees to help them understand about the program, to understand about the deductions and what their benefits will be next year. All right, so before we go to questions, if you forget everything else about tonight, remember this slide. Register your business at ctpaidleave.org. Do not pass go. Do not engage in a frolic and detour. Just go to ctpaidleave.org and get registered. If you have third-party payroll providers, just get in touch with them and make sure that they're processing your wage withholdings. We've been working with payroll providers for several months, so they should all be prepared. They should already have started doing your withholdings, but it's always a good idea to just get in touch. And then educate your employees. You can explain to them about the withholdings. You can explain to them about the new leave benefits using those resources I showed you. And on an ongoing basis, visit us. Check us out at ctpaidleave.org. We have FAQs that we've been updating almost every 2 weeks. We have videos that we're adding. There's always new content, so please check us out. All right. If you have questions and they're not answered tonight or you think of them after the fact, you can check out the frequently asked questions on our website as well as the videos. If you still can't get what you need, you can go to the Contact Us portal on our website and submit your question, and you'll get an email response, or if you request a phone call, we can coordinate that as well. All right, I'm going to stop sharing my screen and see if there are any questions. I wasn't able to see how they came in. So I don't know if you've been answering them through this half hour.
Thank you, Erin. So we actually have one question in the QA right now. How long does it take to get the private plan approved if you've submitted all the required materials, vote, declaration, and bond?
So if you've submitted all your required materials and all of your materials are correct, we have been basically getting them responded to within 1 business day. I can't guarantee that we will be able to maintain that pace, but we absolutely commit to getting them all responded to within 10 business days at the outside. But as I said, right now, our average is within 1 business day.
Thank you, Erin. We don't have any other questions at the moment. If you do have questions, please drop them in the QA at the bottom of the screen. I'm going to use the chat feature to send you all a few links. Let's see if anybody has any other questions.
I can tell you that if you're interested in the private plan option and you go to YouTube and look up ctpaidleave.org, you'll see a number of our videos, including a video we did not that long ago that specifically relates to if you're an employer interested in the private plan option. There's also a video, a step-by-step tutorial on how to submit your application. Those are both available. Again, going to YouTube and just typing in ctpaidleave or ctpaidleave authority or ctpaidleave.org.
Erin, I wanted to share our compliments. So we did get a compliment and a thank you for all that we've been doing to prepare employers for the paid leave plan. So we thank you very much. You know, we understand how challenging it is, particularly in this economic environment, and we are here to help and to try to make it as easy for you as possible. So we appreciate the acknowledgement. Thank you.
I do appreciate that. It's very nice to hear. I do see a question in the chat where someone indicated that they registered, but there was no place for the FEIN. So I'm wondering if perhaps you had registered with Business One Stop and obtained your credentials, which is great because you do need to do that. And you will need to do that for pretty much all your future interactions with the state. But then you need to come back to ctpaidleave.org and click on, there's a button to say registration. And in that registration, there's just form to fill out, and that will include a place to enter your FEIN. Okay, there is this question here about the short-term disability and paid leave overlap. Okay, so if you are an employee who has an employer-provided short-term disability policy, and that employer-provided short-term disability policy says you have to use your employer or state-provided benefits before you come to us. Basically, it's called being the insurer of last resort, or payer of last resort. If that's the case, the employee will go to their employer for their leave request and then come to Connecticut Paid Leave Authority and say, I'm going to be out of work and I'm not going to receive any money, and please give me some income replacement benefits. We will pay those benefits either at the 95% or the 95 up to 480 and then 60% beyond that. The employee could then go back to their short-term disability policy and say, two things. One is, could you make up the difference? Some policies will allow for that, others don't. Or when they've exhausted their entitlement from the Paid Leave Authority, but they're still out of work because it's a significant condition, they could go to and receive income replacement benefits from the short-term disability provider. Okay. Hopefully that answered your question. It's similar to what's going to happen with you when you decide what to do with your accruals. And you do have until, about 10 months to make a decision about how you want to review your policies about whether you require your employees to use their accruals for their own serious health condition or caregiver. As I said, you don't have to. There are many reasons you may want to because it gives you a little bit more control. But whatever you decide to do, you need to notify your employees, and you do have to let your employees hold on to at least 2 weeks of those accruals instead of requiring them to exhaust them all while they're out on leave. So that is something that you will need to consider. I'm not seeing any more questions. So what I would say is thank you so much for inviting us tonight. Please do check out ctpaidleave.org. Please register. We need you to register, and we need you to engage in your withholdings so that you can remit them at the end of the quarter. And check back again. We are developing more content, particularly relating to leave administration, so that as we transition from this contribution and collection phase into the actual claims administration, we can help employers, particularly those who haven't dealt with this before.
All right. Thank you so much, Erin. I appreciate your time tonight. Thank you so much, everybody, for joining us. I hope you all have a good evening. Please note you will receive a copy of this presentation in PDF format and a link to the recording of this video so you can use this with your companies and your employees. And thank you all again for joining us. Everyone have a great evening.
Good night, everyone.